Worldwide, LLC et al. We welcome today Mr. Barrett, Mr. Hagan, Mr. Sieber, Mr. Woodward, Mr. Berkelhammer, Mr. Scoggin, and Mr. Lee, and all of you who attend this historic virtual argument for the Supreme Court of North Carolina. This is the second day in the court's 200-year history that we've had an opportunity to host virtual oral arguments. So we're glad to have everybody here this morning. Mr. Barrett.
Chief Justice, may it please the court, counsel, my name is Alex Barrett with my partners Chip Hagan and Kurt Sieber and Stanley Woodward of the Washington, D.C. Bar. We represent plaintiff appellant Global Textile Alliance, Inc., which I'll refer to today as GTA. Madam Chief Justice, I wish to reserve, if it please the court, 8 minutes for rebuttal.
Thank you.
This case involves GTA's claims that its officers, directors, and employees committed fraud and breached fiduciary and other duties to GTA by creating a web of competing companies for the purpose of diverting business from GTA for their own benefit. The defendants' appellees include GTA's former chief executive officer and its vice president, both of whom were directors of GTA. At the time of the discovery of the defendant's appellee's conduct, the only non-defendant appellee involved in GTA's management was Stefan Hospeslag. Hospeslag has long served as a trusted confidant and business consultant to Luke Tack, the 100% owner of GTA. Mr. Tack is a Belgian national. He oversees numerous entities in a large textile machinery and global fabric manufacturing and sourcing enterprise. He does all of this with Hospeslag's assistance. He serves as an officer of one of Tack's publicly traded Belgian companies and CFO of another. Hospeslag has extensive experience in finance and training in accounting and taxation. He and Mr. Tack have worked together very closely for over 30 years. Hospeslag was Luke Tack's agent for all things GTA, represented Tack in GTA board and management meetings, reviewed financial and other information of GTA, accessed GTA's computer systems, gave guidance and direction to GTA relating directly to the individual defendants, appellees, Stephen Graven, Ryan Graven, and Tim Dolan, and their roles as employees, officers, and directors of GTA, and advising Luke Tack on all matters concerning GTA. So it was natural for Luke Tack to turn to his trusted agent and advisor Hospeslag to help him unravel the web of corporate deceit the two had discovered. There really was no one else for Mr. Tack to turn to. So he instructed his counsel to include Hospeslag in communications regarding this case as his agent. And pursuant to that instruction, Mr. Hospeslag was included on hundreds of emails with counsel. This background is what led to the trial court being presented with the issue giving rise to this appeal. Our arguments generally fall into two categories. First, what is the proper standard for the determination of whether the attorney-client privilege applies in the context of the presence of an agent? And second, what process must be followed in reaching a determination of whether applicable privilege applies. Regarding the legal standard, may an agent be privy to an otherwise privileged communication without its waiver? For decades, this court has recognized that the answer is unquestionably yes. The principal question raised in this appeal is the determination of agency for purposes of application of the privilege. And following this court's decision in Miller and Mervyn, and most recently, the Court of Appeals decision in Barron's, authored by Judge Lucy Inman, the courts have articulated the privilege applies in a situation where the person communicating with the attorney was acting as an agent of some third-party principal when the communication was made. Such communications are privileged. According to this court in Miller, quote, because the third-party principal would actually be the client who is communicating with the attorney through the agent, close quote. Here the agent is Hospeslag, acting as agent for Luke Tack and therefore GTA, wholly owned by Mr. Tack.
And let's, Mr. Barrett, let's talk about that a second, because
yes, sir.
I'm not sure I fully understand the positions of both parties. It seems to me that your argument is in essence that GTA is the alter ego of Luke Tack and vice versa. Is that?
That is a convenient way to think of it.
Okay, all right. Is that an adequate way to look at it?
I believe that it is. The trial court, both the special discovery master and the trial court, recognized there was no distinction between the two. Luke Tack is the 100% owner of GTA. Therefore, he owns and controls the privilege, and he is free as the owner to designate agents. There can be, those agents could be officers or directors of GTA. In this instance, he designated his agent, Stephen Hospice Law, to participate in privileged discussions with counsel.
All right, and I think I understand that. I mean, the question I've got in mind is Mr. Berkelhammer's argument in response to that is, in essence, North Carolina has a fairly strong doctrine of recognizing the corporate entity, and therefore he doesn't buy that equation of Luke Tack and GTA. In your reply brief, you cite that your discussion of this particular issue focused on a case, I believe, from Ark. Is there any North Carolina case that deals with this question, or is this a question of first impression in North Carolina in terms of whether a wholly owned company is viewed as being identical to the 100% sharing?
Justice Urban, the appellate courts, as far as of North Carolina, as far as we know, have not addressed this question directly. We cite the Technetics Group case. The business court has dealt with this issue, recognizing a corporation can only operate through its agents, and by analogy, with Luke Tack being the 100% owner, and as you put it, essentially the alter ego of the corporation, he is certainly free to control the privilege. He is effectively GTA. Again, the trial court.
If the agent of an agent then becomes covered, if Mr. Dolvin or Mr. Graven had somebody like Mr. Happislaw in their conversations, would the privilege be waived in that set of circumstances?
I don't believe the privilege would have been waived. If they had designated a trusted advisor themselves, such as Mr. Hospice Law, who was designated by Luke Tack under Miller and Mervyn as applied in Barron's, the question to be answered, we believe, is simply the question of agency. As long as there is some objective indicia of agency, that is sufficient. But certainly, had the defendants in this.
And let me. So it's your contention that all you've got to show is that there is evidence from which the agency relationship could be found, or does the trial court actually have to make a finding that the agency existed?
Well, in this case, the trial court simply rejected the arguments made by defendants that there was some distinction for purposes of owning and controlling the privilege between Luke Tack and GTA. So that determination was made by the trial court, recognizing that the privilege enjoyed by GTA as the party in the case is slightly different than the privilege enjoyed by the client. Luke Tack is effectively a joint client. He is the owner of GTA, which is the party in the litigation. So the trial court did not linger long over this question. But indeed, as Justice Urban, as you point out, our appellate courts, to our knowledge, have not addressed the question directly.
Do you agree with the business court that the burden is on your client to assert the attorney-client privilege and show that it's eligible to assert it?
The ultimate burden under longstanding precedent and principles laid down by this court, the ultimate burden is on the party claiming the privilege. We do. Yes, sir. That would be GTA. But that's just the beginning, frankly, of the analysis. The standard here is whether that standard is met. As long as the agent, as long as as long as there is some objective indicia of this agency relationship, there is no waiver and the privilege is not destroyed. The
What would be
only
the
issue,
standard of review? What's our standard of review then as an appellate court?
we think the standard of review here, for several reasons, is a de novo standard, that the court should review afresh the facts and matters before the trial court. And there's several reasons for that. First of all, the determination of agency is a question of law. And we believe the appropriate standard for review of a question of law is, in fact, de novo. Also, in this case, the trial court, as the court knows from review of the record, reviewed not the entirety of 5,000 pages involving hundreds of email strings, but reviewed only what it termed, or what it wanted, was a representative sampling of just a dozen of those emails. And this court, sitting as the court of direct appeal from the business court, reviews de novo a trial court's in-camera inspection of documents in which privilege is asserted. So we believe that for those reasons that the appropriate standard of review is de novo. But let me say that it matters little in this instance which standard of review is applied. The court knows undoubtedly from review of the Barron's decision that Judge Inman there applied an abuse of discretion standard, finding there that the trial court had simply misapprehended what the question was, misapprehended that the question to be answered was whether the person who was involved in the discussions as an agent, whether an agency relationship existed, and a misapprehension of the law, as she articulates there based on precedent of this court, can indeed be an abuse of discretion. And so she applied an abuse of discretion standard there and on that basis, she concluded that there was some objective indicia of agency in the record and reversed.
Is there any indication in this record, as you see it, that the trial court misapprehended any of the applicable law?
Yes, absolutely. The trial court did not apply.
Educate me a little bit then. Educate me about them.
Yes, thank you, Your Honor. The issue that the trial court went wrong, fundamentally wrong, in not considering and answering the right question. The right question here is whether there is some indicia of agency. Is there some indicia that Stephan Hospice Log is Luke Tack's agent? That is bound up in the process, which I want to get to in a moment. But instead of answering that narrow question, and actually the trial court found indicia of agency, observed, the trial court observed in its written order that just because Stephan Hospice Log is an agent for some purposes doesn't mean he's an agent for other purposes, thereby essentially finding that he was an agent. The analysis ends there. There is not grafted onto our law the additional requirement that the trial court applied here, and that is, must there be a showing with regard to each and every one of the documents claimed to be privileged, that in those communications, Stephan Hospice Log was acting as agent for purposes of the litigation. That is the standard that the trial court applied, frankly, by surprise to us, given the procedural posture of the way the issue was presented to the court. And that's where the court went wrong. I hope that's responsive to the question. If you want to please, that leads to...
Before you go on, I'm trying to understand your argument as to the scope of the agency. Are you saying he was Mr. Tack's agent for all purposes of the company, his operations, or just for this litigation? Can you help me with that?
Thank you, Justice Davis. He is Luke Tack's agent for all things GTA, including but not limited to for purposes of this litigation, and specifically for purposes of this litigation. As Luke Tack tries to unwind, after he retains counsel in this case, he gives specific instruction to counsel to include Mr. Hospice Log on communications about the litigation. As facts are developed, as legal claims are examined, and ultimately as this lawsuit is brought. So the long history of Mr. Tack's agency of GTA predated the agency being extended and certainly including the facts and matters embraced in this litigation. But the agency is broad. It concerns all things GTA. And effectively,
has that been a consistent position of GTA in this litigation, or has there been some prior issues with regard to discovery, particularly with regard to this gentleman, where the GTA has taken a different position?
We've taken no different position. Justice Newby, if you were referring to the attempt by the defendants to make Stephan Hospice-Log a custodian, which is a term of art, I'll try not to go too deeply into that, for purposes of owning and controlling GTA's documents for purposes of producing electronically stored information. We took the position, the defendants took the position that indeed Stephan Hospice-Log was a member of management. Stephan Hospice-Log was intimately involved in all things GTA agency, and based on that assertion, attempted to make Stephan Hospice-Log, who is a third party, he is an agent, but he is not an officer, director, employee of GTA. They attempted to make him a custodian of documents. The trial court...
As an agent, wouldn't it be true that any communication he had would be subject to being discovered?
Not in an agency relationship. That's the principle in Miller. If the client is at liberty and is privileged to involve an agent in communications with counsel and privileged communications with counsel without
but what I'm
obstruction
talking
of the
about
privilege.
is between the principal and the agent, and the agent and everything else with regard to any communication with the company.
Well, frankly, I haven't considered that possibility, Your Honor. There's not been any attack or attempt to get at, and no questioning has occurred to my recollection and knowledge in the deposition of Luke Tack about his discussions with Stephan Hospice-Log. So the issue before the court is not the conversations and discussions directly between Stephan Hospice-Log and Luke Tack. The issue before the court is the discovery of the email communications between counsel and Luke Tack, which included his agent, Stephan Hospice-Log.
But you would agree that there needs to be a consistent position taken by GTA with regard to that role, that you can't say, well, we want him to have a particular role when it comes to communication with counsel, but we don't want him to have a particular role with any other communication.
We think consistency is certainly important, but there has not been any inconsistency. None has been pointed out in the briefing as we review it, Your Honor. And certainly there is not any inconsistency about who Stephan Hospice-Log is. He is Luke Tack's agent for all things GTA, up to, including, and certainly including, and specifically including the facts and matters embraced in this litigation, and receiving advice of counsel and providing information to counsel as the claims that were brought in this case were evaluated and ultimately brought. So there's not been any inconsistency about who Stephan Hospice-Log is. I will point out, Your Honor, there is a timing difference here. Stephan Hospice-Log's role changed several years after the facts and matters at issue in this case occurred, and actually almost 2 years after the lawsuit was brought. By that time, Mr. Hospice-Log's role as agent for Luke Tack for all things GTA had shifted, was different than what it had been previously. Luke Tack's son, Remy Tack, came to the United States, became the CEO, and assumed many of the responsibilities that previously had been carried out by Stephan Hospice-Log in the agency relationship with Luke. So when Luke Tack is answering questions in his deposition in 2019, what is Stephan Hospice-Log's role? At that point, he had little, if any, role. But previously, he had a tremendous role. And there seemed to have been some confusion on the part of the trial court about that baseline fact. But there is no inconsistency whatsoever about what the record says about who Stephan Hospice-Log is. Luke Tack's affidavit speaks to that very directly about the scope of that agency, and that the agency certainly includes the facts and matters embraced in this litigation.
Is it part of
Do you
the
think the agency determination has elements of factual a need for fact finding? And if so, would you concede that that's an abuse of discretion standard?
Well, the trial court, the special discovery master and trial court assumed that findings of fact were necessary. So we think that's entirely appropriate because this court in Miller says the trial court is to look for some indicia, is to look for some indicia of agency. And so there must be some, at least impliedly here, no findings of fact and conclusions of law were requested. But the special discovery master and the trial court felt that they were necessary. So yes, given the instructions by this court and the Court of Appeals to trial courts that the inquiry to be made is to look for some indicia of agency, then there is inherently in that process some fact finding, whether it's explicitly expressed in findings of fact and conclusions of law or not. The other aspect here, Your Honor.
Mr. Barrett, is it part of your burden to show that his presence, Mr. Hezbollah, I'm mispronouncing his name, but that his presence was necessary in order for counsel to do his or her job effectively, like in the cases we've looked at in your briefs where the agent had specific expertise in accounting?
No, Your Honor, it is not our burden to show that. That, frankly, is the Covell doctrine speaks to that. The functional equivalent doctrine that we have referenced in the briefing speaks to that as well. That this court need not revisit the well-established principles in Mervyn and Miller, as most recently articulated in Barron's. The functional equivalence doctrine and the Covell doctrine, functional equivalent of an employee and the Covell doctrine are simply different ways, in our view, to think about this agency relationship. Our courts have not adopted, there's not an appellate decision in North Carolina adopting either the functional equivalent doctrine or the Covell doctrine. And I think that's for good reason, because Miller and Mervyn have stood the test of time. The question here is whether an agency relationship exists. And so we need not make some special showing about functional equivalency or about the Covell doctrine that the person is needed for purposes of the representation. That is certainly the case here, and there is a great deal of evidence that would support GTA winning on those points, but it is not necessary.
You're not necessarily asking us to adopt the functional equivalence or the Covell doctrine?
They are alternative grounds, Your Honor. Again, we think they are unnecessary for the court to reach them. We think the question that's been articulated by this court to be answered by the trial court is very simply whether an agency relationship exists. Is the person who is consulting, involved in the communications with counsel, is that person the agent of one of the parties? Here, there's a mountain of evidence about Hospice Log's agency, and there's more than enough evidence to satisfy frankly, a fairly low burden of showing some objective indicia of agency.
So going back to Justice Irvin's question earlier, is the only issue of first impression that you're asking us to decide the alter ego issue?
I believe that there is no other issue of first impression in this case unless the court chose to move beyond the agency doctrine that's been well established in Mervyn, Miller, and most recently articulated in Barron's, and chose to extend the jurisprudence of the state to adopt the Covell doctrine or the functional equivalency doctrine. But that is not necessary to do in our view, given longstanding precedent of Miller and Mervyn, that the question to be answered, the central question to be answered as Judge Inman said, is the question of agency.
Can I jump in here for a second? I've got a question about the trial court's order. Talks about the third party's involvement, i.e. Mr. Hospice Log's, must be merely indispensable or serve some specialized purpose in facilitating the attorney-client communication, and then go on to say that the court adopts the special discovery master's findings and says that he was not Luke Tack's employee or agent, or that his presence during communications was necessary or highly useful for the effective consultation between GTA or Luke Tack and GTA's outside counsel. Are those factors as important as that the trial court appears to think they are? And if not, what's the authority for that one way or the other?
Those questions are the questions to be answered for purposes of satisfying the requirements of the functional equivalency test. Was hospice log the functional equivalent of an employee, or the Covell doctrine? Is his presence highly useful or essentially necessary in order for there to be effective representation? So again, it's an example of the trial court having gone astray here and answering questions, frankly, that either were not asked or it did not need to answer for purposes of making the determination about agency. So the question, in our view, Justice Hudson and members of the court, is quite simple. Does agency exist?
And what do you contend are the important factors in determining whether there's agency for purposes of answering this particular question?
Just some indicia of agency. An agency is created, as the court knows, so long as there is control, agreement by the agent effectively to serve, and control of the agent by the principal. That's what's needed to be able to show agency, and certainly a close advisory relationship in many contexts. And this court has recognized that family members, in the case of Barron's, it was a friend and an advisor who also happened to be a lawyer. So it really doesn't matter what the profile is of the agent, so long as the frankly minimal requirements to show agency are met and there's some indicia of that agency. That is the question to be answered, and it's the only determination to be made in our view.
While the attorney-client privilege has to be jealously protected, of course, how does your argument mesh with the liberality of discovery, especially where there is a third party involved with an attorney-client privilege, as to the perceived leniency that discovery should have in terms of how you're making your argument, as compared to, of course, the other side looking to have privy to the discovery information that it wants?
Thank you, Your Honor. Discovery is far-reaching, and unless there are privileges to be respected and not invaded, then essentially everything that can have any possible relevance is available for discovery. But that does not erode in any way the primacy in our jurisprudence about the importance of the attorney-client privilege for the fair administration of justice, nor does it erode the attorney work product doctrine that reserves as inviolate from discovery the mental impressions and the work product of counsel engaged on behalf of a client. So while discovery is far-reaching and is extensive, it cannot be permitted to invade the attorney-client privilege or the work product doctrine.
Yeah. And I opened my question with the recognition of that, but you've got the situation here where you've got a third party involved, which quite often the appellate courts have looked at as being a waiver of the attorney-client privilege, even when it's unintentional because there was a third party involved. And yet here, to the extent that we may be making some landmark law, how would your argument impact that aspect of discovery?
If Your Honor, please, it would be an error to regard Stephan Hospice log for purposes of our law, as this court has articulated it in Mervyn and Miller, as some third party. He is not a third party. As this court observed in Miller, when counsel is talking to the agent, counsel is talking to the client. So the communications that are being had by the attorney with the agent are with the client. And so he is not some stranger. He is not someone whose presence is inadvertent or intentional to destroy the privilege. He is the client. If he is in an agency relationship, as this court has recognized in Miller, he's the client.
And Mr. Barrett, I just want to let you know that you're well into your rebuttal time.
Oh my goodness. Thank you, Your Honor. I will reserve what remaining time I have. Thank you so much.
Thank you, sir. Mr. Burklehammer.
Madam Chief Justice, may it please the court. My name is John Burklehammer, and along with Mr. Stephen Scoggin and Ms. Scotty Lee, we represent the appellee Steve Graven. Today, I speak on behalf of all appellees. Stephan Hospice Law, who was not an employee, agent, officer, or director of GTA was privy to communications between GTA and its client and its lawyers. Under this court's precedent in State v. Mervyn, those communications were not confidential and any attorney-client privilege have been waived. Two experienced Superior Court judges, one sitting as a special discovery master and one reviewing that decision de novo, found this to be true and were absolutely correct in doing so. The decision of the business court, therefore, should be affirmed. In addressing this issue, if time permits, we also would like to address a couple of jurisprudential issues, such as the subject matter waiver and the judicial estoppel issue that's been talked about earlier. The facts of this case are relatively straightforward for purposes of this appeal. Plaintiff Global Textile Alliance is a North Carolina corporation. It has a large manufacturing facility in Reidsville where it employs 300 people and is the largest employer in the county. Throughout its existence, it has observed the corporate formalities. As alleged in paragraph 4 of the verified amended complaint contained on page 4 of the record, Tim Dolan was the chief executive officer and a member of the board of directors from inception of the company through April of 2016. On paragraph 6 of the verified amended complaint contained on page 5 of the record, it is asserted that Steve Graven was the executive vice president and a member of the board of directors from the inception of the company through April 2016. Remy Tapp followed Tim as chief executive officer, and Kim Thompson followed as chief financial officer. Stefan Haspislaw, on the other hand, has never been an employee, officer, director, or agent of GTA, and no one contends otherwise. Regarding the role of Mr. Haspislaw at GTA, Luke Tack testified at pages 581 through 585 of the record that Mr. Haspislaw does not have a role with GTA, does not have a title with GTA, did not have any role in making the decision to bring this litigation. He also testified significantly that the litigation has been entrusted to the chief executive officer.
Mr. Berkelhammer, what do you make of Mr. Barrett's argument that, well, that was true as of time A, but the time is time B, and therefore the trial court's findings are based on a misapprehension of the record?
There's nothing in the record to support that, Your Honor. Neither Mr. Haspislaw nor Mr. Remy Tack provided an affidavit in opposition to this. The deposition testimony stands uncontradicted. Luke Tack's affidavit does not address this purported timing issue. Rather, there is no evidence to support the assertion, at least in this record, that something has changed. This is a 300 employee facility. It is not, which has observed the corporate formalities. It is, in fact, the client, and it is the client for purposes of this litigation.
I mean, in my discussion with Mr. Barrett, he basically accepted my characteristic of his argument as essentially saying that Luke Tack was the alter ego of GTA, and then argued that under that set of circumstances, a 1% shareholder ought to be treated as essentially the same thing as the corporation, acknowledged that there wasn't any North Carolina authority on this point, one way or the other. What light can you shed on this issue?
Certainly, Your Honor. This court's decision in Board of Transportation versus Martin upheld the corporate form. And in doing so, it noted that once you elect the benefits of the corporate formalities, you cannot sort of go back on that in an effort to gain advantage later. Rather,
do you disagree with him? I understood Mr. Barrett to acknowledge that this court had not previously addressed the sort of question that we have here. That's presumably why he cited the Oregon case that he cited. Are you aware of any decision in this state that deals with the specific question that we've got here, other than general pronouncements about corporate formalities and their importance?
I am not, Your Honor, and I don't believe that the application of the corporate formalities depends on whether or what type of situation you want to avoid the corporate formalities. I don't think the corporation or has the ability to say, oh, I want to hide behind the corporate form on fact situation A, but I didn't want to avoid the corporate form for fact situation B. Whereas this record shows you have a long history of observance of corporate formalities, then those corporate formalities ought to be respected. And that's what we are asking the court to do here. It's not new. Otherwise, the change in allowing a fact-specific or determination as to whether someone can waive its corporate formalities and then jump back into the corporate form would be terrible on the trial courts of this state. And so it's our view that Mr. Haspeslaw, who has never been involved in this company as an employee or an agent, cannot be simply the agent of the shareholder. If we think about larger corporations with larger shareholders, shareholders don't have the privilege. Somebody on behalf of Ford, who is a shareholder, cannot demand attorney-client privileged information from the company. It is the company's privilege. And that is where we believe what makes this case easy to sort of resolve.
So, Mr. Berkelham, are you saying the rule's no different at all, even in a case where there is one person who owns 100% of the company?
I would not go absolutely no different at all, but yes, I was very close to it. On this record, where you see the corporate formalities observed with 3 members of the board of directors, a person who is the CEO who is not the sole shareholder, a person who is the executive vice president who is not the sole shareholder, where they have addressed and have retained a chief financial officer. This is not some small one-person corporation, but on this record, yes, there is no reason to disregard the corporate formality. And once you accept it, I believe the Board of Transportation decision was essentially 2 people, a husband and wife, who were trying to assert or avoid the corporate form to have their property considered contiguous from a taking perspective. And this court said, no, you have accepted the benefits of the corporate form and they should be respected. And we just ask that they be respected here.
Just so I can understand, I'm sorry if I jumped ahead of Justice Hudson. Were you trying to ask a question?
I was, but my mouse missed. Sorry. Thank you. Just a quick question. I think, Mr. Berkelhammer, what formalities would be sufficient in your view to have given Mr. Haspeslaw the benefit of the privilege here?
Well, first of all, sure. If it were from either from GTA or assuming it's from Luke Tack, in Barron's, they had a written agreement. The actual agreement specified that the friend or former lawyer was acting for the benefit solely of the litigation, that the friend was necessary to protect the interest of the client, which is a factor in Mervyn, and that there would be information would be expressly held confidential. And so there was a scope of the relationship. There was an agreement on behalf of the alleged agent that they would be an agent. And then there were other differentiations as far as how far that would go and why this was being done. In this instance, we have simply a friend, a confidant who is alleged to be this wide-ranging agent for all purposes. Yet Mr. Haspeslaw did not provide an affidavit. He did not say, I'm the agent. He did not say what the scope of the agent was. He did not say what control was being exercised over him, all of which are factors for agency, and there's nothing in this record to support that. To the contrary, if we look at the affidavit of Luke Tack, we say that Mr. Haspeslaw has other duties. He is the chairman of the board and chief financial officer of a company called Tessenderlo in Europe. He serves on the board of directors of a company called John Davidson, I believe. He serves on the board of directors of Picanol, serves on the board of directors of Cellpac, and serves on the board of directors of Findar. It is hard to imagine that somebody like this is under the control of Luke Tack for a company that is in North Carolina. And there is no evidence to support that he is. And so even if we look at, which we do not believe is correct, what the evidence is to support agency, the evidence is absent. And to the contrary, there is evidence that the litigation, according to Mr. Luke Tack, was entrusted to Remy Tack, not Stefan Hasbuslaw, and not Luke Tack. Mr. Tack testified in his deposition at pages 581 through 583 of the record that Remy Tack was entrusted with the litigation, that he did not keep up with the details of the litigation, and that Mr. Remy Tack did not report regularly to him. Under those circumstances, whatever his alleged agency of Mr. Hasbuslaw was, it was not the litigation, because that was given to Remy Tack. And so what we have here is simply communications made that were not in confidence, which is one factor under this court's decision in State versus Mervyn, and communications that have otherwise been made to a third party that have been waived.
So my question was somewhat similar to Justice Hudson. So I understand you're not saying that Luke Tack could not have an agent for the purposes of addressing the litigation and communications with counsel. But am I understanding you to say that if he wanted to have such an agent, it would have to be established in writing that made clear the scope of the agency? And if that's your position, is that really where we are with agency law, that there has to be a written agency agreement in order to establish an agency?
Well, my initial position is that, as always, the privilege belongs to the client. And in this situation, the client is the corporation. And if we look at the two privilege logs contained in the record, we note that GTA in providing its privilege logs said the client was GTA. So that's the first step in determining that. And certainly there can be an agency relationship with Mr. Hasbuslaw and GTA that has got to be sort of an agreement in some fashion. It doesn't necessarily have to be in writing, Justice Earle, so I'm not doing that. I was responding that what could be available, and that's what we saw in Barron's. But we have nothing from Mr. Hasbuslaw saying that I agree to be under the control of this company and be told what to do by this company. And when I don't do what I'm told to do, I have consequences because I'm an agent. I am under the control of someone or something else. And there is nothing in the record that makes that clear, that makes any evidence of that. What we have is the opening statement of the affidavit that I am a personal friend of Stefan Hasbuslaw. Well, we all have personal friends and we all talk to them, but that doesn't mean that that person is my agent for any and all purposes of my life, no matter how long I have known them. And that's the quote indicia, some indicia of agency that is sought to be made here. And there's agency requires more. It is a factual showing. It is not a legal showing. It is a factual showing of scope and control, both of which are absent here.
And so then you would disagree that the trial court in determining, making it, so the master set out findings and then his conclusion that there wasn't an agency here was a conclusion in the legal, conclusions of law section of the order. But you're saying there wasn't any legal error in how the trial court applied the agency principles here, and that all we're dealing with is a factual determination.
Correct. It's clearly an abuse of discretion on the facts. Both the special master and the business court de novo reviewed the evidence before it. It had deposition testimony disclaiming agency. It had deposition testimony disclaiming control. It had deposition testimony showing that somebody else was tasked with the litigation. It had deposition testimony that Mr. Tack, Luke Tack, did not keep up with it. It was certainly within its right to credit that testimony. On page, I believe it's 634 of the record, the business court goes through, and I think it was Justice Hudson who looked at that, said all of the evidence that was missing with respect to this issue. And the business court and the trial court had every right to weigh the affidavit and look at the testimony. And given that the affidavit was conclusory, self-serving, after the deposition testimony, it had every right to reject that and accept the deposition testimony previously made under cross-examination by counsel for the defendants. Now, in this court's decision in Ray Miller, the court expressly noted that conclusory, ipsy-dixit statements do not satisfy a party's burden. And that's all we have here are the conclusion that he's my agent, he's my confidant. That's all we have to rely on in this record. And we have much evidence to show that he was not the agent. He was certainly not the agent for purposes of this litigation. And we do believe that is a factor that needs to be considered.
You would agree that if the board of GTA or if the officers of GTA had gone to this gentleman and asked him to be their agent for purposes of this litigation and advising the board, advising the officers, that would have been an appropriate retaining or the retaining of an agent.
Justice Newby, I believe that under Mervyn, the presence of a third party or agent needs to be necessary to protect the interest of the client. And so I think that when we're talking about the attorney-client privilege, which is construed narrowly, I think one thing you would need to look at is whether that person's presence was necessary to protect the interest of the client. But otherwise, sure, the board could have said, we want a special committee to monitor the litigation, or we want a special committee to keep track of the litigation. But those normally are within the board, and they do not stretch outside the board because that person, unless that person brings some special expertise to the board, it would be rare that you would just have an agent for that purpose, a need for that purpose. So like I say, at Mervyn at page 531 of the formal reporter, the court noted that neither the aunt nor the friend were necessary to protect the interests of the client. And as we look at Covell, which is a corporate situation, and we look at the functional equivalent of an employee, we see that necessary link, that to have agents for litigation, there's got to be some link between the agency and the litigation.
Your argument seems to assume throughout that the entity that would be involved here, or the individual interest that would be involved here, is not Luke Tack, but it is the corporation. If we would happen to find that Luke Tack and the corporation are one and the same because Luke Tack is the sole shareholder, would this change any of your approach to your argument?
It does, Your Honor. First, of course, that would be fact-finding at this level. But yes, there would still be a need to find that Mr. Haspislaw was the agent for purposes of the litigation. And as we saw, Mr. Luke Tack testified that he tasked the CEO for that purpose. So on the record shows that there was somebody already tasked for purposes of managing the litigation, and that was the CEO of the company.
Is there any requirement that there can just be one?
Well, I don't believe there's a requirement that just be one, but when asked what Mr. Haspislaw did for the company, Mr. Luke Tack said nothing. He has no responsibilities for the company. So it's hard to find out that when someone has no role for the company, to then come in and say that he's the agent for the company for managing litigation. The record just doesn't support that assertion.
But if Luke Tack is the corporation, as Luke Tack sees himself as being the sole shareholder, then by way of, I was never that great in math, but I did learn the transitivity theory. Does that mean then that if Luke Tack is the corporation and if Hoppus Law represents Luke Tack's interests, then it would stand to reason, if you follow that line of thinking, that arguably Hoppus Law therefore is representing interests through Luke Tack of the corporation.
If the record supported that he was to do so for purposes of the litigation, that may be true, but the record doesn't support that. And the record doesn't allow me to be a sole shareholder, form a 300 employee corporation, have it be the largest employer in the county, and then say, I have this personal interest that's identical to the company. And then I want to then transfer that interest to my friend because it's convenient. And as we know from the Covell Doctrine and others, this is merely a convenience. Convenience does not protect the attorney-client privilege, nor should it. It's a very narrow privilege. It is the privilege of the client.
So, Mr. Berkelhammer, I was
I'm wrong in thinking that if we open this door and say, well, the company and the shareholder are one and the same alter ego, would that not also open the door for the counterclaims, kind of piercing the corporate veil, if you will? So if there were counterclaims against the company, 100% owned, how do we protect a corporate form and yet say, well, 100% shareholder, although technically the shareholder, if they've appointed the board and they can maybe remove the board, but in terms of directing the company, that would be the board and officers. What am I missing here about the danger of saying that a company is just an alter ego of an individual?
Well, you're not, Justice Newby. As a matter of fact, there are counterclaims. Lawsuit, counterclaims filed by Mr. Graven, counterclaims filed by Tim Dolan, and counterclaims filed by Dolvin Incorporated. All of those counterclaims are pending and are asserted against the company. And you're right. If you can avoid the corporate form whenever you want, then everywhere there will be claims asserted against individuals.
So, Mr. Berkelhammer, just so we're on the same page, am I understanding you right? Under your argument, if we reject the alter ego theory that the plaintiff is advancing, it doesn't matter whether he was the agent of Luke Tack for purposes of the litigation, correct?
That's correct. Although the record shows he was not, but that's correct, Your Honor. If it's the privilege of the company, and the company it has waived that privilege by permitting Mr. Hospice Law to be privy to those conversations. There are 5 parts of State v. Mervyn, 2 of which are whether the communication was made in confidence, and the 5th one was whether the communication had been waived. And here, a straightforward application of Mervyn shows that these communications were not made in confidence and that they were intentionally waived.
But even if hypothetically there was just abundant evidence in the record that Luke Tack set up this agency relationship with him to be his agent for purposes of advising him on the litigation, it wouldn't matter because the client is GTA.
That's right, Your Honor. The client is GTA, and that's indisputed in the record. It's the plaintiff. It has asserted the claims. It claimed the privilege. And I would note that the privilege logs note that. And there, as we know from the record, there was an exchange of emails between the court and counsel for plaintiff regarding whether the emails would be submitted in camera. And those are contained at pages 1611 through 1615 of the record. And counsel at that time for GTA writes the court and notes that Mr. Luke Tack has retained separate counsel with respect to his interest on the production of documents, and that separate counsel, Jan Peters, has retained North Carolina counsel, David Brown, to protect Mr. Tack's individual interests in the production of documents from Belgium. And then counsel for GTA goes one step further, and they say that we do not believe the business court's order applies to Mr. Tack in his personal capacity. They have taken the position every chance they have to distance themselves when it benefits them to prevent discovery. And yet when they realize that there's a problem, they've waived the privilege. Communications are not made in confidence. They have want to disregard the corporate form and make everybody the same. This company has fully and scrupulously abided by the corporate form, and there's nothing in this record to make that not true. Otherwise, as Justice Newby noted, every litigation with the company now drags in the shareholder, or maybe the majority shareholder, maybe all the shareholders, because they're all the company. And so,
there's been no veil piercing claim asserted in this action so far, right?
That's correct, Your Honor. So this litigation has proceeded since August of 2017 by a corporation against its some of its officers, former officers and directors, and that's the way it proceeded. I mean, otherwise, the litigation just becomes, the law becomes unmanageable if the corporate form can just morph into and out of the benefits of the corporate formalities. Now, we've talked, I'd like to address in the time I have left the issue of, I guess, subject matter waiver. And beginning on page 11 of the plaintiff's brief, it actually quotes from an email from Mr. Tack to counsel, and then it quotes an email from Remy Tack to counsel. And then throughout the remaining 80 plus pages of that brief and 50 plus pages of the reply brief, counsel repeatedly refers to information it claims is privileged by summarizing, citing to, or quoting from those allegedly privileged communications. Now, that constitutes a subject matter waiver. That is an intentional, affirmative use of privileged information, leaking it out at what it believes to be a strategic time in an effort to gain advantage in this litigation. And the advantage, what they want to try to show that there is just some indicia of some unknown agency. But then when you actually want the documents, they're privileged. Now, it is clear, now just Judge Conrad in the Technetics decision noted that when you intentionally leak out privileged information, you have effectuated a subject matter waiver. And so irrespective of all of this, this jurisprudential reason allows for these documents to be produced. And so I'd like to address one last point, which was one that Mr. Barrett, I think, was going to address and may address in his last minute, which is the process used by the court. As we know, the plaintiff did not submit any emails to the special discovery master for in-camera review. When it came time to de novo review, the plaintiff did not ask the business court to look at those. Rather, it was the business court that asked for those. And at that point, the plaintiff was at a fork in the road. It could either agree and produce a sample, or it could object and tell the court that I want them all. And the plaintiff agreed, and its failure to make an objection under Rule 10A means that it cannot even raise the process issue. So we believe that any process issue in this matter is not properly before the court. Well, I have just a few seconds, so I will conclude. It is our view that GTA failed to meet its burden of showing that these email communications were made in confidence and were not waived, nor have they shown that Mr. Haspeslaw was an agent and necessary for the presence, his presence was necessary to protect or use the attorney-client information. For these reasons, we request that the order of the business court be affirmed. Thank you very much.
Thank you, Mr. Burklehammer. Mr. Barrett?
Thank you, Your Honor. In the brief time I have left, on the issue of agency, Luke Tack's affidavit, and an affidavit, of course, would be the way that these issues would normally be addressed. Testimony that's been referred to from Luke Tack's deposition, Mr. Tack has no obligation to adduce testimony in such a deposition. He addressed these issues foursquare in his affidavit. It's in the record, page 511, and I'll excerpt from it quickly. Mr. Hospice Log says Luke Tack served as an invaluable confidant to me as I received legal advice regarding the matters giving rise to this litigation. Mr. Hospice Log was instrumental in advising me in conversations with GTA senior officials in anticipation of this litigation. He continues to serve as an advisor to me and contributes to conversations as my agent. He contributes to conversations between senior management officials and outside counsel on my behalf. There can be no clearer evidence of agency. The process that Mr. Burklehammer referred to a moment ago was fundamentally flawed. The ESI protocol that had been established by the court was frankly ignored in the process employed by the special discovery master and by the trial court. The question that was raised and the motion proceeded on this basis was—
Mr. Barrett?
Yes.
Your time is up, sir.
Thank you very much, Madam Chief Justice.
Thank you. Thank you, Mr. Barrett, and to Mr. Burklehammer and to all counsel. Madam Clerk, would you please recess us for the day? Madam Clerk, I think.
Oh, yes, oh, yes, oh, yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.